to sort of warm you up. Some would say maybe tune you up for tomorrow. And so we start by maybe trying to put the fear of God into you a little bit, or maybe the fear of juries. Because I do death penalty work in Texas, I pay attention to things like, how do the innocent get convicted and sentenced to death? Well, they get sentenced to death because we death qualify juries, which is not something we're worrying about here today. But they do get convicted for all of these reasons, because, and this is these numbers, percents of these cases, right, but 79% of the wrongful conviction cases had eyewitness identification, or we should say misidentification, had crappy forensic evidence in 55% of the cases. In 18%, they used informants. And in 16% there were false confessions. Do these sound like any cases we know or have this week? All of those are present in the cases you're dealing with. And so it's not just the Mario Dodds of the world who we have to worry about being falsely convicted. They really are our clients. And they count on us to unravel these cases, ideally at the beginning, not on the back end, for people who are doing habeas, because that's the lousiest way to get unconvicted, I assure you. Who's likely to be falsely convicted? Like black men, accused of raping white women. There's a much greater risk of false conviction. What? Yeah. What a shock. Young suspects are at greater risk of false confession than other suspects. This is from a paper by Sam Gross and Barbara O'Brien that they presented to the Law and Society organization in Berlin last year. And you know, there's all of this academic interest in how false convictions happen. And certainly some of it is seeded by CSI, Law and Order, pick your villain. But folks, it also starts with us. Because if we don't know the law, and more particularly if we don't know the evidence, then it's a lot easier to convict our clients. I spend part of my life reading trial transcripts. Admittedly, I read them in capital cases. It will shock you to find out how in cases where the most significant item is at stake, a person's life, lawyers don't have hearings inquiring into the veracity of evidence, inquiring into the veracity of snitches, seeking to suppress evidence. So now, of course, admittedly, some of you are going to say, well, that's Texas. That's where she works. It's a strange place. You know, guys who sleep can try cases. But really, it happens in other places as well. So our obligation as lawyers really is to learn what's in that little red rules book that was handed out to you and to use it strategically, because this is a good way to torque the prosecutor and to torque him or her for ways that the judge can get behind. Because how many of you have been in a courtroom and you feel that the judge would be inclined to rule for you, but the judge is afraid? The judge is afraid of blowback from the prosecutor who's elected, from the police who are a force to be reckoned with at the next judicial election, from victims groups in the community. I don't know about your community, but I got a victims group in Houston that lobbies for the death penalty. Isn't that great? They call it justice for all. Okay? So, like, the way that you get around those political problems is you know the rules and you cite the law. And I'm telling you, it works. Because the last two cases that I've won, and this really frightens me to death, we're in the Texas Court of Criminal Appeals. You know, it's like, how screwed up do you have to be to win cases there? And those were death penalty cases. I mean, this is the court that couldn't stay open for an extra 15 minutes so that our client, Michael Richard, could file papers. This is the court that said that my other client, Charles Dean Hood, should have found out that the prosecutor and the judge were sleeping together during his trial. and that latches maybe should be applied against him. So it's a crazy court. But I'm saying if you know the law and you know the rules of evidence, you can be much more effective. And the bottom line is when it comes to evidence, the evidence that you're going to offer and you're going to seek to exclude should always promote the legal theory and emotional theme of your case. There may be things that you do for strategic reasons, for record reasons, but by and large, if you're getting up on your hind legs and you're objecting, it should be because this stuff doesn't promote your theory and theme. If you're seeking to offer it, it should further your case. Otherwise, you're wasting everybody's time, and the jurors figure that out pretty quickly. Because when you're just sitting on your butt and you're not able to ask questions, why, in a situation much like this one, the bullshit detector is fully turned on high. So follow this particular rule as well as you can. The way that I organize my cases is I always want to think about what's my evidentiary trouble. And for those of you, you're all courtroom advocates. I am sort of half the time. The other time I'm doing it on paper. I do this even in my habeas cases. I want to know what's the narrative. What is the story that I must tell to get my client out of hot water? What is that legal theory and the emotional theme? And what's the evidence that I've got to offer, that I have, that I can use to further that? What demonstrative evidence do I want to use? In my office, I'm made fun of because I came to NCDC and I listened to the Burton Islamic lecture that you're going to hear, and I went and created my store of demonstrative evidence. And now when any lawyer in my office goes to a hearing, they stop by my office a couple weeks in advance and we map out what demonstrative stuff they're going to do. And they sort of make fun of me that I have all this stuff, that I've got little cars, and I have markers, and I have 12 different sizes of foam board. But because Bert taught me how to use all that, we're always thinking of creative ways of showing judges and juries, fact finders, how things really did happen. And I also want to think very hard about what are the evidentiary problems I'm going to have with each piece of evidence that I need to use. And I do that long before I'm walking into a courtroom, because nothing builds credibility with a hostile judge more quickly than knowing this is how it comes in. This is why it comes in. Judges will back off and they won't listen to the prosecutor. And sometimes you'll start to be able to get evidence in that maybe there is a legal argument on the other side, but your argument will prevail because the judge will believe that you're right based on your prior behavior in the case. Now, one thing that I always want to do in pretrial is anticipate the other side's objection. Things have gotten a little bit easier since Holmes versus South Carolina, which is the case that essentially says, and I'm paraphrasing, that you can't use the rules of evidence to keep out legitimate, relevant evidence that somebody else might have committed the crime. You can't use the rules of evidence to keep out evidence that legitimately furthers your case. Essentially what the court is saying is, hey, the Constitution's pretty strong and the defense has got it on its side. And I take it as meaning the rules of evidence predominantly apply to the prosecution. Now, maybe I go a little too far. But I'm going to put in motions pre-trial that say things like, I'm moving to admit evidence of the real killer. All right, because that's really what I'm trying to do. And when the prosecutor goes in and he reads that motion, he knows exactly what I'm trying to do. The judge does, and so does the newspaper reporter whose fingers are doing the walking through the pleadings file. And if I'm denied the opportunity to introduce this evidence, I'm going to renew at trial. And in Texas, I'm going to make an offer of proof because I have to in order to preserve the error, and take the evidence up on appeal. But I'm going to do this because this is how I'm going to get it in, and sometimes if you say it often enough, the judge may say, I'm denying, and finally at trial, you'll be permitted the opportunity to do this. This worked recently for a friend of mine in Houston. You know, Winston Churchill, never give up, never give up, never give up. It's not bad advice when it comes to our evidence, because prosecutors well know that most of the time they've got, you know, more evidence than we've got, and they can devote a lot of firepower in their office to keeping our stuff out. So don't give up. Now, when you're at trial, your objections have got to be specific. You've got to have a specific objection, and when you're meeting the objection, you need to have a specific response. Don't let the judge run over you, particularly if it's a really important issue in your case. It's a piece of evidence that you don't think should get in. It's the outcry, it's the witness who the state says is the outcry witness in a child sex case, but you don't think it is. It's because it's the third person the kid talked to. You know, and it's not witness number one, it's not outcry person number one, it's outcry person number three. You want to have a specific response to that, not just objection, Your Honor. I always like to consider trial briefs, you know, on the big stuff, we see them coming, with that coming, we see it coming down the road. It's a reason that we may seek to negotiate the case. It's a reason that we sit down with the client, we say, Bubba, it might be time to consider a plea. Or maybe sitting down with the prosecutor and saying, it might be time for you to consider making me an offer my client can live with. But if you see it coming, there's no reason not to write a trial brief, because trial briefs make judges afraid. That's called papering the record. And judges don't like to be reversed. They kind of go into their chambers and stomp around for a while. Do you want to make an offer of proof? In some places, you must make an offer of proof in order to preserve the objection. You've got to know what your rules are for preserving the error. And do you want to interrupt the flow of the trial? Do you want to, you know, say, let's take the jury out and go in and, you know, and make this offer of proof, or do you want to wait till the end of the day? I think these are strategic issues, but you know, you really ought to be thinking about them in advance. You don't want to do them on the fly because, you know, it pisses people off. And it also tends to be the sort of thing that you don't get a complete error preservation. And certainly in places where you have hostile courts like the Court of Criminal Appeals, they say there's no preservation.
You should always make an offer of proof, mostly because you should know why you want to get it in. And you should make that offer of proof, if not for you and for the judge you're in front of, for the habeas lawyer, for the next lawyer, for the appellate lawyer. If you don't say why you think it should come in, no one's ever going to know. And the worst thing that can happen is you've committed to something that hopefully you've prepared and set up already. And an offer of proof will back a judge off a lot quicker than almost anything else, especially if it's done live where they have to think and respond. Because if they have to think and respond, they're much more likely to change a ruling to keep something out, because something in it sounds like, oh my God, I better let this in. And that very often is the only decision they make.
And the other thing I always want to consider is, when I'm making an offer of proof and it's a witness that they really want out, I really want that witness to take the stand in the offer of proof rather than me just proffering. Because live testimony is something that the appellate court can review. The court then knows exactly how it would have gone down and can make some judgments about effectiveness. Whereas if you're just sitting there summarizing, saying, well, you know, Bubba's mom would have said that they were watching Dancing with the Stars instead of when at that time, well, kind of around the time that maybe he was robbing the convenience store. Whatever. Get Bubba's mom on, have her testify to that. It'll be a lot clearer, and appellate courts are human beings too, and they want to know the human story. So you want to tell that.
The other thing is when you're doing an offer of proof, you may be able to take a chance to find out whether you got a little extra or a little more after you've done your job. And by the other token, if you're forcing offers of proof from the other side, you have a free cross-examination without a jury in the box. So you have a free shot at the witness.
Right, which in places where you don't get discovery can be awfully we want to plan to make evidentiary trouble. You cannot play this game unless you know what the prosecutor's theory is going to be in your case, the theory and theme. If you haven't figured that out before you walk into the courtroom, you're not ready to defend. Fortunately, cases don't have that many storylines. Something bad happened to some person, and your guy did it. And really all the rest is commentary. But still we want to know, what's the prosecutor's theory? And what sort of evidence, real, testimonial, is the prosecutor going to use to prove her case? And that means, what witnesses does she have to call? And what else is coming in? Is it the so-called rape kit or sex assault evidence kit, whatever they're going to call it? Who is going to come in and testify? And what I love to do, and in the age of the internet and scanning, this is a lot easier. I go and look up other cases that the prosecutor has tried, like mine, if not like mine, other cases she's tried. I actually send law interns to the courthouse with a portable scanner now and a laptop. And we just scan in trial records. And so we start looking at, how does this prosecutor regularly deal with this sort of evidence? What are the sorts of things that she does on opening and on closing? And then we file motions to keep her from doing that. It's really great, because then you can attach transcript pages that show that, yeah, in this case she did that, and then this other case she did it again, and in this third case she did it another time. And particularly where those violations are things that courts have been inclined to call harmless error, you have a greater shot at showing harm in some respects by showing that she's a repeat offender. I mean, this is where I sort of use 404B, other bad acts, kind of against the prosecutor. So, but you can't know what evidentiary tricks she's engaging in unless you have somebody go look. And for those of you who say, I am awfully short-handed, well, you know what? The economy is here to help you. There's a whole generation of law students, and in fact, graduating lawyers, who folks are so frightened that they're not going to get jobs, they are looking for real work. And they're willing to work for you for free in an internship for a period of time, as long as they can get a good letter of recommendation from you. I'm serious about this. Go find those people. They are out there. In fact, for the next year, there are a lot of lawyers from big law firms that have been paid a quarter of their salary. Well, hey, $180,000. A quarter of that salary is, well, almost what I make a year. And they've been paid to sit at home. So what places like my shop are doing is, we're having them come in and work on cases, because it's real work. So you can find a lawyer who will do that, who would be willing to do that, a law student, to help you go gather this information if you don't have time to go sit at the courthouse and scan. And then, once you've assembled this information, you have to decide, what's my plan for dealing with each piece of evidence? This is how we find out that junk science is junk science. Not by dealing with it on the fly, but by dealing with it in advance and really thinking about this strongly. There's a psychologist in the state of Texas who's very likely to lose his license due to some advanced planning on my part. And the state is going after him. There's a dog scent expert in the state of Texas I'm going to do the same thing to. He's not licensed, but we're going to send the puppies home. And because frankly, it bothers me. Now, I'm helping other people with the dog scent expert, who's not in my case. But it's part of this advanced planning, you gotta do it. Yeah. In terms of trying to keep out their evidence pre-trial, you can move to suppress, you can make a motion in limine. But remember, on those motions in limine, if they're denied, you've still got to articulate prejudice, because most appellate courts are not going to overrule a denial like this unless they understand how you are harmed. And you've still got to object again at trial. And I might add, re-articulate prejudice. Articulating prejudice is helpful for another way. Suppose the appellate court pours you out, and you're a state court defender, and some nice lawyer down the road says, I'm going to take this up in a post-conviction motion. First at state, I'm going to go to the federal courts and federal habeas. If there's not prejudice, that's accrued from this evidence, then you're just not going to win on habeas. So you want to get prejudice in there. You do have a strategic consideration about planning to make this objection pretrial, and that is, how much does surprise benefit you? There are some lawyers who do lay behind the log with certain parts of the state's case so they can torque the state after the prosecutor has promised the jury that certain types of evidence are going to be introduced and then they're not. But I think you have to play that game very carefully, and particularly when we're talking about, you know, the DNA evidence that you think is suspect. I'm not sure I would wait until the trial to raise all of my Daubert or my, whatever your state equivalent is, objections to it. And in fact, I had this conversation last week with a lawyer regarding some forensic evidence. And it's an expert for which we think he's got really bad practice on his area of expertise. And we've also caught him in lies that go to his credibility in other areas. And the lawyer said, I really want to have a Daubert hearing, but I'm really afraid that if I bring everything out that I know in the Daubert hearing about this guy, that the state will adjust, and then at trial, they will have trained him not to do the things that he normally does, and that I could have otherwise impeached him on. And so I said, you know what, on the Daubert hearing, you know, you've got such good stuff on his bad scientific practice, I would leave the credibility stuff for trial. You know, so you'll have impeachment at trial about stuff he's lied about in the past and that he tends to lie about not regarding the science. But you're still getting that Daubert hearing because you really need to test that evidence right up front. And you really, and judges don't give you good Daubert hearings, quite frankly, in the heat of trial, in my judgment.
And you don't want to do a Daubert hearing just before trial. You have enough to do, it's hard enough, and the last thing you want to do is be switching from the scientist to the lawyer and back and forth to try and get it out. And if you're going to do it, if you're going to do a Daubert hearing, you need your experts, you need everything lined up, and that's trial in and of itself. So the earlier you can get the Daubert hearing, and it doesn't matter even if you have the hearing and they rule against you, the rule of confusion to the enemy. Right? The prosecutor's now worried about what happened at the Daubert hearing. They're almost like not worried about the trial because you can harvest from the Daubert hearing things for your cross-examination that you've auditioned and tried out and understood. And then your expert gets to look at the Daubert hearing and starts to show you where their expert is trimming, changing things where the science isn't as good.
It permits you, what I do is I go back to the medical library, I go back to the regular research library, and based on representations that their expert always makes about it's in the literature, I go through the literature and am able to find stuff that's directly in contravention. So I have more impeachment. So as David says, please do that as well as you can before trial. Now, when we make these objections at trial, you know, they've got to be contemporaneous, specific, and you got to get a ruling. You know all this. But a ruling is not always just overruled. And you've got to know your local rules. In Texas, your ruling under our appellate rules must be specific. Overruled isn't good enough. The judge actually has to articulate it, why he's overruling your objection. So we are training lawyers to say, Your Honor, under Texas Rule of Appellate Procedure 3.1 or whatever the hell it is, I need you to articulate your reason for overruling my objection. And eventually, you train judges to do this. Now, you may also need to seek a limiting instruction if the judge allows that evidence in, if your jurisdiction requires that. My jurisdiction does. What's the problem with the limiting instruction? Yes, it sort of tells the jury, you can't consider it for this reason. And you all know that they go back and consider the evidence for that very reason. It only goes to his identity, it doesn't go to his guilt here. And they all go back and say, well, you know, because he did that in the past, he must be guilty here. And there's, unfortunately, research that kind of backs that up. So that's why we go back to what you're doing with evidence has got to further your theory and your theme, and you're not just getting up willy-nilly and objecting for the hell of it, because you're objecting at for the stuff that really hurts you. And I don't know, is there a reason that you might not seek the limiting instruction and not preserve that error? I think I'd be really careful with that decision.
Or craft your own limiting instruction.
That is
Craft your own limiting instruction so that at least you've given the appellate court the instruction that you wanted, rather than the instruction you got stuck with. And then this may be a little off, but like, the circumstantial evidence instruction that y'all hate, with the umbrellas in the rain or some shit like that?
The subway, I never understood
stupid.
that, yeah.
They do, well, in New York they do the subway, but I don't know if they can do that else. Anyway, the idea is that they've given a circumstantial evidence instruction at the end of the case that can only lead to the inference of guilt, right? The umbrella's wet, they come into the courthouse, it must mean it's raining outside. Well, that instruction for us sucks. It's terrible. It basically says, guilty, 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 guilty. Right? So you gotta do something else. You gotta look at that instruction and craft your own. And like the one I use is you come into the courthouse, you get onto the elevator, another person gets onto the elevator, they press the same floor you're going to. You can circumstantially infer that that person is a juror, a witness, a friend of the judge, someone who wants to watch the trial, but without more, you don't know the answer to that. Judges go like, that's interesting, and we'll give it, because it's fair. It's completely fair. And prosecutors, to use Catherine's word, torque. Their heads just kind of go all the way around and come back. Because they know that suddenly the guilty instruction has become just a possibility. You can do that with limiting instructions. You don't say, well, what you can't do is use it for this. Tell them what they can use it for, and stop. Because, Judge, all we want them to know about is why you're letting it in. Not all the reasons you're not letting it in. And they go like, yeah, does that sound reasonable? And one prosecutor say, no, you gotta know what the bad things are, because if they don't hear about the bad things, they won't know to go that way, Judge. So what you're doing is truly getting a limiting, because it's supposed to be a limiting, not an aggravating instruction. But I digress.
Because now David is going to take over and he's going to talk to you about the law underlying making the objections at trial and how you're going to keep stuff out. And now these are really the big three: hearsay, privilege, and prejudice. And we're going to start with hearsay.
Okay, look. Everybody gets up and says, objection, hearsay. And then their brains freeze. Right? Because you say, well, what is hearsay? And we get into it's an adequate statement of prove the truth thereof. Right? And a sentence that ends with thereof doesn't mean anything to anybody. Right? And if you say, well, there's the Brooklyn Legal Aid objection, which consists of, objection, Your Honor, this is killing me. Right? That's kind of what it is. Somewhere between this is killing me and thereof is what hearsay is. You ready? Here's how you do it. Is it up there? First, who's talking? Because it can't be hearsay unless somebody says something. Now, we did a mob case for 18 months on trial in which they put in evidence from the 1920s and 1930s, statements of co-conspirators who were dead almost as long as we've been on trial. Right? And the question was, objection, hearsay. The government, no, co-conspirator statement, total totality of the circumstances, quackity, quackity, quackity. Right? One of the lawyers got up and said, objection, Your Honor, due process. Due process? Well, not really. Right? The judge, who had a sense of humor, looked down and said, well, I don't think that's a good objection. Given the evidence, perhaps the issue is the age of the statement. Right? That's a cue to most normal people. Some guy in the back row, who my name was, leapt up and said, objection, Your Honor, seance. No, you don't get a seance because the guy's been dead. That's not an objection to hearsay. It's an adequate statement often for the truth thereof. First, who's speaking? Why is hearsay important? Because it's coming in as a statement that's not cross-examined. You have the right to confrontation. Hearsay exceptions are the things that say they're the equivalent of confrontation. So, who do you want to cross-examine? You want to cross-examine the guy from 30 years ago? Or do you want to cross-examine the agent who's coming in to say, oh yeah, I read a report back in 100 years ago where that's where I heard it. Who do you want to cross-examine? Under what circumstances? Is it the lying sack of shit that walks into the police station saying, here's my opportunity to get back at Joey because Joey's got my wife? Under what circumstances was the statement made? And for what purpose? Why is it being offered? Because the purpose it's being offered for determines whether or not it's hearsay. If it's offered as a co-conspirator statement, it may be admissible. If it's offered for some past recollection of some historical event that has no relevance to what we're doing, except that it hurts the defendant, objection, Your Honor, right? Then the purpose is not a permitted purpose to allow a hearsay statement in under an exception. And if it's outside the exception, as a rule, it's not going to come in. Now, why is all that important? Well, the whole idea of court and testimony is face-to-face confrontation with your accuser. Hearsay skips that. Hearsay says, no, we don't need such a confrontation. It's unusually reliable. And now, as you see the Supreme Court, we're going to talk about this a little more later, we're totally eviscerating the idea that the statement's reliable for one reason or another. These questions are what you ask yourself about whether or not it's admissible. Things that have surface admissibility, when you go through the 4 questions, suddenly become not admissible. Hearsay. Just because they say it's an exception doesn't mean it really is. Now, what happens when the person who's speaking, the declarant, isn't available? Dead, really dead, sincerely dead, any one of those versions. Unless, of course, there's some other problems in the case, you have the right to impeach the speaker, the declarant. You always have the right to impeach the declarant. So, if you can't get him face-to-face on the stand for any reason, you can still dump all the shit you got on him into evidence. And they can't do anything. It's even better than usual. And the prosecutor's got to take it. How does that work? Well, in a co-conspirator situation, we tried a matter in which the speaker was a guy named Sandy the Bull, Sal Gravano, who was the turncoat in the Ghana case. Right? We wanted to cross-examine him. For reasons not important to us, he was unavailable. And he wanted to talk about how this union ran. And he gave a sworn statement how the union ran. So they wanted to put the sworn statement into evidence. We objected it. Seriously, it's this, it's that. Absolutely not the judge, because it wasn't a real trial. The judge says, no, I didn't let it in. Now, you can impeach the declarant all you want. I can impeach Gravano all I want. And he's not going to be there? I got 7 trials in which he's testified. What we did was we took all the trials, we put all the answers together, and lined them up one after another to show how every one of them was different to the same friggin' question, one after another. It was like shooting fish in a barrel. And we did it because it was so informal. We did it in an affidavit. I did an affidavit. If I were allowed to cross-examine Sandy the Bull, this is what I would do. He would say this, I would say this, he would say this, I would say this, he would say this. I mean, this is like a dream, right? The witness isn't even there. You get to write all the parts. It's like television. Judge ruled, right, the monitor, and the proceeding ruled that Gravano wasn't credible on that affidavit, right? So, the unavailable declarant is always available to be impeached. It's great fun. They can't fight back. If they don't come to the party, they get a beating anyway. All right, I love it. Maybe you'll learn to love it. Privilege, right? Before I get to non-hearsay, let's talk about privilege. There are all these great privileges. Right? Under 501, I think it is, of the federal rules, It says, look to your state courts for privileges. And if you look in the state code, there are all sorts of incredibly stupid privileges. Why are there stupid privileges? Because someone hired a lobbyist to go to the Capitol to get a law passed that said, whenever you go to a podiatrist, he can never speak of the relationship, right? So minimum fee are completely protected. The idea is that privilege allows you to keep out reliable, truthful, useful, devastating evidence. What does that mean? Well, in the case we tried, we were able to keep out, the client was charged with killing his wife, which wasn't so bad, and tossing the body out of a moving Cessna, which, yes, you can do it, thanks for asking. And it was a video they showed to prove it. And not with a wife, but with an equivalent weight. At least that's what they told us. Anyway, the doctor, the psychiatrist who treated the defendant, was so moved by our client's plight that he brought in all the records of our client's fantasy life of murdering his wife. And not like for a year, not for 2 years, but for even before he married her. These people didn't need marriage counseling. They didn't need a referee. They needed some sort of, I don't know what they needed. Anyway, whatever they got didn't work out for them either. So the doctor gives the prosecutors the psychiatric records. And the judge, who's now running for DA, if you live in Manhattan, don't vote for him. If the judge, now running for DA, said, I don't see anything wrong with this, because after all, she did. But there was a privilege. And so we litigated the privilege. We were going to have a hearing. The psychiatrist was, out of his mind about having to testify. And we were trying to line up experts, we're trying to line up this, we're trying to line up that. We even tried to get amicus. We called the lawyer for the American Psychiatric Association, who told us to go fuck ourselves. That was a very professional opinion. And by the way, he did. I'm not exaggerating. So I figured, well, okay, fuck me, I think I'm going to return the favor. I called the president of the American Psychiatric Association, told him the entire story, said, your lawyer told me to go fuck himself, but let me tell you that if this decision goes the way this judge is going to write it, you will never have another patient again. It will be August all year round. He understood that completely, remarkably enough, and they filed an amicus. The judge backed off with an opinion that included such things as the legislature should immediately change this law, which is preventing this vicious person from being convicted. But don't worry, I'll take care of that at trial. Which she did. By the way, best offer of proof from that trial? We go up to the thing, we're ready to object to a piece of evidence, and the prosecutor, who came straight off the slab, right out of the castle, through the torches, where the villagers with the torches, lurches up to the sidebar and says, oh, we're not going to offer that. And I'm going like, cool, nice, good, let's see. Just get away from the sidebar. Judge goes, you're not? Well, I could think you could offer it for this, you could offer it for that, you could offer this, you could offer a hat, you could call me Jim, you could call me Johnson. Kase goes, well, I guess we'll offer it then. And she turns to me, the judge, and looks at me, and I look at her. She looks at me, and I look at her. And she looks at me for a while, and I look at her for a while, and she goes, Mr. Lewis. And I went, oh, I'm sorry, Judge, I was waiting for an equally cogent argument for our side. because no one quite knows what to do with me when I get like that. Can I tell one? I want to tell this story because I want to tell you never to do this. This is a story you should never do. When New York had a capitalist statute, I had a capital case in which my client, through the infelicitous use of dumbbells, not people but the lifting things, decided that two people who were in his house, who apparently were sleeping, needed to have the dumbbells applied to them for remedial purposes, repeatedly, and thereby created an installation of an abattoir in his living room. And things got worse from there. By the way, you know that thing friends call friends to move bodies? It's not true, he found out. Because all 4 people turned his ass in right away. The case is set for trial in Orange County, which is north. Not really far north, but far enough so the rich, fertile air doesn't seem to get into the judges' heads. And we had a system in which they had trial judges, they picked trial judges who could try death cases in the city of New York, known as not mouth breathers forced onto the public by the political organization, but real lawyers. But they didn't have such a thing up north because, well, in the northern part of the state, that would mean nobody could try a death case. So they had these complicated rules, which really weren't rules. And my judge in this case was a complete and utter fucking moron. I mean, if you turn his head, you can hear the air whistle. And in New York State, you're entitled to 45 days if your client makes a statement, which of course my client had to make a statement because someone turned a video camera on. Why else are they there for, except for confessions? And you're entitled to 45 days by statute and 45 days by case law. You would think those 2 things might be convincing. We go in on the first appearance, we do the arraignment, judge says, well, let's do our motions. All the motions, capital motions, everything. He gives me a date. I said, Your Honor, I think that's only 42 days. The statute and the case law gives us 45. Do the best you can. Well, the rules say that death qualified judges had to know the law, case law, and the statutes. I took this personal. And in my 850 pages of motions, do the best I can, I teach the best I can. In the 850 pages of motion, I made a motion, and I swear to you this is true, it's been seen by others. A motion for a smarter judge. Because I thought you should know that the 45-day rule, right? Talk about motion in limine. And remarkably enough, it didn't get granted. Although, it did look like he was thinking about it.
Yeah, tell him about the part when you asked for payment.
Well, it was an $80,000 motion, but it was worth every penny of it, and would not do it again. Anyway, okay, so we did here say we did privilege. Prejudice. Prejudice is very simple. It's hurting my client. Now, it's got to be unusually prejudicial. Right? Under the federal rules of the 403, it's got to be incredibly prejudicial, as opposed to the government version of, Judge, I need that to prove guilt. Oh, I'm sorry, I don't know how I got in the way of that. Well, please, let it all go in. But unduly prejudicial. The idea of 403 is that you make the 403 objection. It's a balancing test by the judge. Usually an unbalanced judge makes a balancing test, and you're trying to keep it out. So the idea is to try and use those rules to make your motions. The other idea is that you're going to get discovery, you're going to get information about the other side's case. You're going to force them to justify what they want to put in. You're going to also force them to work. This confuses most prosecutors because they think there should be a plea. They don't really care who it is. They'll take a plea from anyone. But they think there should be a plea. So once you start making motions, they say things like, well, you know, this is really serious. I mean, now we gotta, someone in our office has to pull up the usual shit and change the name of the defendant and file that. And we're angry. Right? So you want to do that. Non-hearsay. Some things come in because they're non-hearsay. Admission by a party opponent. By the way, the government's a party opponent. So sometimes you can get in shit about them because it's an admission by a party opponent. And it's a lot of fun. They scream. They hate that. Because they've made statements in the course of the case that could be used. Backrack, don't write that down, not in the Second Circuit. But everywhere else. Prior sworn inconsistent statements of the witness. Does that sound familiar? That's impeachment. But you can get that in. Why? Because it shows they're a lying sack of shit. You can hold it up. You can say, touch it. Touch it. It's a lie. Touch it. Right? It gives you something to give them. You notice how we never have any evidence to give them? I know Belzer had all those photographs, but most of us, you know, what do we got? Sure, they show up with all those drugs and baggies and scales. You gonna believe that shit? Right? I mean, we don't have anything. We don't even have toys to roll around as a guy. I mean, so we gotta give them something. Paper's very good. Co-conspirator statements. Now, we talked about hearsay. Let's talk about hearsay exceptions. Why are they important? Because that's how evidence that shouldn't come in comes in. Now, you're going to all read the rules. Tomorrow you're going to read the rules. If you're in my group, you better stay up and read the rules, because I only say three things all day. Read the rule or read the fucking rule. By the way, when we get to the fucking rule part, that's not a good thing. Right? And the two important questions about evidence, which also are very important in the rest of our lives: can you get it in? Can you keep it out? You can use your own imaginations about why it's important. Now, so here are the exceptions. There's a whole list of them. You need to know what they are. You don't have to write this down. You just have to listen. This is important, to listen, because you've heard this before. So it should be, well, fake that it's familiar, right? And these are the three that everybody fucks up. So let's do them together. First, present sense impression. It's describing or explaining an event or condition made while the speaker was perceiving or immediately thereafter. Perceiving or immediately thereafter. This is a microphone. I see it right in front of me. There are people out in the audience. This is a present sense impression. Next, an excited utterance. It's a statement relating to a startling event! That's a very important piece of it. It has to be a startling event. Not just something that happened. While the declarant, the speaker, was under the stress of excitement by stress of excitement caused by the event or the condition. Caused by the event or condition. So, if you see something during a knife throwing act or it's a car accident, it may not necessarily be admissible. It's not caused by the event or condition. Next, then existing mental, emotional, or physical condition. A statement of the declarant, then existing state of mind, emotion, I want to get out of here, sensation, God, I wish I left already, or physical condition, such as intent, plan, motive, design, all those things. But it's not, and this is where everybody gets hung up, a statement of memory or belief to prove a fact remembered or believed, unless it relates to a will, which we're not going to have. Right? We're not doing estates. So unless it relates, it can't be a statement of memory or belief looking backward. So while the declarant's perceiving it, while I'm feeling it, and then what was happening but right then and there. What happens in criminal cases? They're basically cases about what? Something that had already happened. That's why these rules are important. It keeps out stuff. And if you know these rules and you get up on your hind legs and say them, well, you know, then how do you do it? The judge is thinking, I gotta open that book. Bullshit, I can just sustain this objection. Then I get to lunch quicker. Right? The idea is if you sound like you know the rules, and you know the rules, and you stand up and do it, you will keep things out. You will keep things out that maybe you shouldn't even get in. If you're feeling frisky, you just object because it's the right thing to do. And the judge may keep it out. By the same token, if you know the rules and you know what the case is saying, sometimes you can do something. I tried a case in which my client had a set of phone records that she insisted were real. Subsequent investigation seems to contradict that, along with her guilty plea. But let's put that aside for the moment, because like most clients, she thought she should help her case and gave them to the lawyer to put into evidence, because whose license is more important than anybody's freedom, right? What do you think about it? New York is a common law state. We don't have any rules of evidence. We don't have any rules of evidence because nobody can agree what they are. And in a common law state, the great thing about it is, oh, there's always a case for something. It doesn't matter what it is. Somebody somewhere wrote a case and let it in, let it out. You can always find something. There isn't, so I put in the phone records. Government prosecuting judge, you come up to sidebar, that judge says, well, you know, they say they're fake. To which my response is, oh, they say everything's fake. Well, no, that's not really a good response. Right? There's a case in New York. It says that if the object that you're offering, ready, is a fake, it is still admissible if it has an issue of reliability, and the issue of whether or not it's fake goes to the weight. Appellate division, 4 of them, 5 of them, found their way to that answer. So I argued that case. Judge looks at me and smiles and says, there's no way I'm letting this stuff in on that case. I don't care. Stop handing it to me. It's not coming in that way. I said, well, what about the fact that it's a business record? He goes, but it's a fake business record. Aha! But it is a business record. And I turned to the witness. I said, Your Honor, let me ask you a single question. Were these documents kept in the regular course of business? Yes. Is it the course of business for this company? Yes. Ha! A business record, Your Honor. Judge goes, comes in as a business record. We spent 6 weeks litigating whether they were fake or not. Could be, Doc. That's my final answer on that. All right. We have the confrontation?
Yes, and
How much time do we have? 0? Okay. I'm going to do this anyway because we have no time. The only thing you need to know, is Melendez-Diaz versus Massachusetts. It came down this term. You can find it on the internet. You don't need a book. All right? It even has a friggin' number. Something, 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 U.S., something, something, something. 577 U.S. and blank. 2008.
9.
9. Says 8 on
Sorry.
this thing.
Yeah,
All right. Okay. I'm going to go through this with you very quickly. You ready? First, you need to know that they can't put in forensic testimony by affidavit.
Correct.
Right? Because you have a right to confront them. Pretty damn simple. But what's great about this case, and it's worth reading, and it's written by Scalia, because under the I'm a thorough prick doctrine of opinion writing, he has gone through the dissent and anything and the briefs and has said, by the way, there have been a lot of other arguments raised and they all suck. And here they are. He says, 1, that there's no such thing as an accusatory witness limit to the 6th Amendment. Just because they come in and they're kind of neutral doesn't mean there's no confrontation. He says the fact that they're written well before the trial, that's got nothing to do with it, right? That they're volunteered statements, doesn't matter, he says, right? The absence of interrogation, so it's not under 6 months, doesn't matter, he says, right? He's on a roll. Oh, it's an official business record? Bullshit, he says, read 8038. It's a police report, it's not coming in. That it's neutral scientific testimony, don't make me voff, he says. It's not uniquely immune from manipulation. He attacks forensic science evidence in this opinion. It's great, right? Oh, the defense has the power to subpoena. He says, not the same goddamn thing, you idiots. That's the 5th Amendment. Can't you fuckers tell the difference? And then the DA's Association, that vaulted group, that wonderful collection of misfits, filed a brief, you ready? That said, this would just be too burdensome on us. Including things like, it's a long way to drive to the courthouse. I mean, no shit, you gotta read it. It's really a hoot. And he says, task too burdensome? You gotta be kidding. He says, the confrontation clause may make the prosecution of criminals, he's still a dick, remember? They used to be the innocent accused, but of criminals more burdensome. But that's equally true of the right to trial by jury and privilege of self-incrimination. I read that and held my breath and said, the bastard's taking them. But no, he says, the confrontation clause, like those other constitutional provisions, remember they used to be guarantees, let's not get excited, is binding. Binding, that's it. But how does a binding? Is binding and may not be disregarded at our convenience. Well, he has proven once again that once a term, Justice Scalia almost gets it right. Someday, he and Thomas will have that high-calorie, large, fat meal and go to that great big court in the sky. But until they do, once a term, he comes through with something, and I'm sure he does, just to fuck with our heads. And I believe that's what we're going to do with you tomorrow on evidence.
Oh, thank you. Thank you.